Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. The question that we often get is, I got somebody who's lying about me, wants to get a PPO against me, says I'm stalking them, says I'm harassing them, doing all these things. What do I do about it? So the first thing you got to understand is, why would somebody do that? And I'll tell you why somebody would do it. A lot of people think, if I can get a PPO against my spouse, keeping him or her away from me, then I'll be able to get custody of the kids because I got the kids, and since they can't come over to me, they can't see the kids. A lot of people seek out PPOs to jockey for position in a custody case. Believe it, they do. It's the wrong thing to do. If the court believes that the only purpose for the PPO is to jockey for custody in the case, the court will probably set aside or deny the PPO and say, well, let the custody judge handle it. What do you do if somebody's lying to do this? They have signed a PPO. They got a preliminary ex parte PPO because they claim you've been harassing them, you've been showing up at their work, you've been assaulting them, you've been threatening them and all this stuff. And it's all a pile of horse feathers. It's just a bunch of lies. It's just something that doesn't exist. Well, what you do is you contact your lawyer immediately. Your lawyer will file objections to the PPO and ask for a evidentiary hearing on it. And you will get the opportunity to have the allegations heard and to refute the allegations with your own evidence. If the court believes that the allegations are false, the court will set aside the PPO. But remember one thing, always in the back of the court's head is the PPO based on a legitimate good faith belief that the person is in jeopardy? The court may think, no, it's not a good faith belief, it's just a person who wants to get custody. Or the court could think, you know what, this is really a person who's worried for their life. So they got a PPO. The court's balancing that. So your proof has to be convincing to the court that the PPO should be set aside. Now, I'll give an example of someone who had proof, as they thought, but the court didn't buy it. We once had a person who claimed that they were wrongfully part of the PPO, that their ex said that they were continuously calling them and calling them. They were exes. This was an ex-girlfriend, and she was claiming that he, from Illinois, and she's in Michigan, that he just won't leave her alone. Constantly calling her and calling her, blowing up her phone day and night. She can't sleep. She can't rest. Disturbing her at work, and so she sought out a PPO. He comes in with proof that all these calls, they're not mine. They're not from my phone number. Here's my phone number. That's a different number. The court listened to the testimony. The court listened to her testimony, kept the PPO in place anyway. The court didn't believe that a stranger would happen to blow up his ex-girlfriend's number all day. The court believed, more likely than not, he's just using someone else's phone in order to harass her. That was one part of it. The court chose not to believe the testimony. Also, the fact that that guy came into court with his wife, who made a scene in the courtroom, well, that didn't help him much either. More likely than not, what was truly going on in that case, by the way, he probably was harassing that person. His wife found out about it, so he said, it's not even my number, somebody else. He found a way to do it, but he was still harassing her because he had a grudge against her. I don't really know. I say more likely than not because that's what the findings of the court were. Certainly, obviously, in a situation like that, the attorneys argue, look, I don't know what's going on, but I can tell you it's not my guy. That's not his phone number. That's not it, and blah, blah, blah. But the court has to assess whether or not the parties are telling the truth. How do you respond if somebody's lying? You try to produce evidence. The court, though, always has the discretion to believe you and believe your evidence or not. So you got to remember that if you're going to try and set that PPO aside, you got to have evidence that's convincing and makes sense to the court. A plausible explanation. Perhaps this person had another boyfriend, and that's the one who's calling. More likely than not, that's what was going on. But the court has to be presented with different options so that it can address the issue. So remember, she's lying, you better have proof. And not only must you have proof, it better be convincing proof. Because even with good proof that's convincing, remember, it's the judge's gut instinct whether or not to believe you or not to believe you, whether to believe her or not to believe her. If you have any questions, reach out and we'll be glad to help you out.